Пане Олеже, добрий день.
Oleg, good afternoon. Welcome at the second stage of the selection process for the HQCJ, and the Selection Commission is holding the interview within the following composition: Robert Brookhuizen, me, Ivan Mishchenko, Serhiy Verlanov, Stephen Markman. The members of the Selection Commission, Ted Zarzeczny and Evhen Mezentsev, have announced self-recusals. Ted Zarzeczny has announced self-recusal because he participated in the selection to the High Anti-Corruption Court with you, and Evhen Mezentsev because you are in the Mria company together with him in the territorial defense. That's why we will have 4 members of the Commission. If for some technical reasons the interview is interrupted, the Commission will definitely reach you and we will continue the interview at some other time for technical reasons. Suppose there is no connection or suppose there is an air alarm or anything like this. So there are 4 of us, so I think that we will have enough time to have a talk with you. But anyway, the request is that you give concise answers to the core of the matter, and the member of the Commission asking the question can actually limit the time of your answer. At the beginning of the interview, the Selection Commission will give you a chance to present yourself, to tell about your motivation, about what urged you to participate in the selection, what ideas you've got concerning the operation of the new HQCJ and concerning the judiciary in general. You're welcome to do this within 5 minutes. Oleg, you're welcome. Once again, good afternoon, dear commissioners. Let me also welcome all those who have joined the interview and the broadcast of the interview. I'm Koliush Oleh. I'm the judge of the High Anti-Corruption Court of Ukraine. I have a wife whom I love, and we have been in marriage for 19 years. I've got 2 sons. Ihor, the younger one, still a student, and the elder son has been at war within the armed forces of Ukraine for since the beginning of the war. And my hobby is hunting. I realized that the society requires and demands changes in the judiciary, revival of the trust in the judiciary, and is waiting for the operation of the HQCJ. And I'm a candidate for this responsible position of a member of the HQCJ. The decision was passed by me on the basis of my professional and life experience and my willingness to be of use for Ukraine. I started my career while studying at the Ukrainsky State University, from which I graduated with honors. I worked as a legal counsel at different companies, and then in 2001 I passed the exam and got the certificate to practice law, and after that I became a practicing lawyer, at the same time working at private companies. I came to the judicial position as a result of the selection of 2011-2012. This was the first selection held by the HQCJ, and I worked in the court of Luhansk district court. But because of the armed aggression of Ukraine by Russia, which was back then called anti-terrorist operation, in 2015 I had to be transferred to Avtozavodski district court of the city of Kremenchuk. And then when I won in the selection of 2018-2019, I was appointed judge of the High Anti-Corruption Court. Besides that, having an active standpoint, I could not remain aside from the positive changes happening in the state. That's why in 2016-17 I participated in the first selection for the judges of the Supreme Court. And I confirmed my ability to work within the court, but my ranking was a little bit too low to pass. In 2020, I presented my PhD thesis and got the degree of PhD in law. Realizing the need to be ready to rebuff the enemy, starting with the beginning of the armed aggression of Russia in March 2022, I went to the voluntary territorial defense forces unit in Kyiv, and in October 2022 I passed the exam and entered the military department of the National University of Defense of Ukraine, named after Ivan Chernyakhovsky. During my professional career, I decently performed and keep performing the duties laid on me on the state. I've never been given up to pressure, and I've never been abusing my power in my own interests, on the interests of other people. Taking into account my professional experience, achievements, skills, and abilities, indicators and the peculiarities of my performance, participation in different competitions for filling in the vacancies, my professional and life behavior, the results of different examinations, I think that I meet the requirements for being a member of the HQCJ under the law. I realize how many incompleted procedures the new composition of the HQCJ will face, but I'm sure I can work with this, and as a practitioner I have some suggestions concerning the innovations that would lead to better results. I think that the strategy of the development of the judiciary has some proposals on the opportunity of using some outsourcing in the selection of judges and qualification assessment, and I think that these proposals are right, and that could be done through engagement of scientists, researchers, and retired judges in the tracking of the exams. Also, it's important to develop better methodologies for tracking psychological and moral qualities of judges, and this could be done through the development of the methodology of transfer of the conclusions and the results of testing of moral qualities and general qualities into the score, because there is no methodology like this. And of course, this causes some doubt both with alien observers and with candidates concerning the objectiveness of the procedure and availability of too high discretion in setting the points to a specific candidate. The program, the state anti-corruption program, also has a suggestion that exams and tests can be taken remotely if we follow the guarantee of video recording and independent performance of those tasks. And since I have the practice of writing practical assignments, I would also suggest that these tasks should be written not manually, as it was during the competition to the High Anti-Corruption Court and the Supreme Court, by using computers, or we could replace such tasks with a set of a number of cases, the answers to which can be given through filling out specific windows in the computer, or some margin within 200, 250 words. We shouldn't forget about the problem of interaction of the HQCJ with the Public Integrity Council, but this is the issue which is rather difficult, controversial, and needs to be scrutinized and discussed in detail. Also, I consider it's necessary to develop external communication of the HQCJ, to have awareness-raising campaigns among citizens concerning the requirements set to candidates and the assessment methodology. Awareness of the society concerning...
I fear that you went through your 5 minutes, so if you don't mind, we will start the interview.
I'm sorry, Ola, right at the beginning, I failed to introduce your rapporteurs. These are, in fact, my colleague Robert and me. So I do agree with my co-rapporteur. You have really run over this period of time of 5 minutes, so let's get down to questions. Sorry, I did not follow the time. But can you see the figures in the screen? Yes, now I can see them, but I just didn't pay attention to that.
Well, I can imagine. Can you? I'm sorry to disturb you so rudely, and of course, as a judge, you're often the one who interrupts, and the other way around is not so normal, maybe. Can you tell me how you prepared yourself for this interview?
Well, I watched some of the interviews that were broadcast live, and of course I got acquainted with the documents to which I was given access. I also sent my explanations on some matters to the Commission. That's it.
Okay. I have noted me see, that in parallel with this competition, you also participate in the competition for the High Council of Justice. Your letter of motivation, which you sent in the competition to us and to the Ethics Council, they are quite identical. What is your idea? Is your idea to be a member of the HCJ, or is it both? Is not possible, I believe, by law. No. Would you be sad if you would not be elected in the HCJ? Would be selected here to be, let's say, a second prize, not winner, but second? How do you see that?
Can I give the answer? Yes. Good. So really, after the selection was announced for the HQCJ, I made the application, I prepared the documents, and after that, there was also selection announced to the High Council of Justice. And having some work experience and some willingness to still make the judicial reform launched long ago happen, and being willing to help my country with the rebuilding and reconstruction of the rule of law state, where the judiciary would not evoke any negative opinions in the society. That's why I decided to submit both selection processes, to the HQCJ and to HCJ. Of course, if the highly distinguished commission recommends me for the HQCJ, I will stop my participation in the competition for the HCJ, which is still going on.
But that would be a pity, because then you are not. It's not possible for you to be selected in the High Council of Justice. Well, in fact, these two institutions, judicial self-government bodies, have a great role to play. And it depends where my role could be more important. I mean, where I could be more useful. And I think that most probably the High Qualification Commission of Judges of Ukraine could be the commission where I make better contribution. Okay.
Though I also feel that I could work in either of those institutions. It so happened that the competitions were announced one by one. That's why I submitted my application to both.
The point I'm asking the question is that I find it difficult, if I think about it, to be willing to select someone who would prefer to be somewhere else, because then the motivation is not good enough to be elected. And the work in the High Council of Justice, of course, very different from the work in the HQCJ.
Well, it's different, of course. And of course, the High Council of Justice is the constitutional body, while the HQCJ is the judicial self-government body, which mainly deals with staff issues.
Yeah, indeed. Mr. Co-Rapporteur.
Thank you. Do I get you right that still the best possible place of your work could be the HQCJ? Yes, I think so. Why? Why do you think so? Well, I've already referred to the fact that I've got the adequate experience and that I have participated in the selections for judicial positions. I've got the necessary skills and abilities, and I could actually apply them while being a member of the HQCJ of Ukraine. In your motivation letter, among the steps the HQCJ should take in order to improve its operation and performance, you refer to the awareness of the society of the procedures the candidates have gone through, the process of assessment, so on and so forth. What is your suggestion concerning conveying of this information to the society? How shall we do this? Well, I think that this mechanism has already been launched. It was launched by the previous composition of the HQCJ, but I would rather develop it a little bit. I think that it's necessary to publish the tasks and assignments that are performed by judicial candidates or by judges during qualification assessment. And in that way, the society would come to know how difficult the tasks are, how difficult practical assignments are. And with this in view, you could also invite recognized experts in the field of law who would tell about this. I would also try to convey to the society the information about the special characteristics of the testing of moral and psychological qualities of a person and general skills of a person. And I would tell how they assess what people have to do while taking those tests. Of course, without telling the details and the content, but telling about the procedure and how integrity is checked. This needs to be told for people to understand what is the path the person has to go along to confirm the ability to be a judge or to become a judge. And then I think that the trust of this judiciary in the society would go up. Please tell me, as the person who participated in the competition for the Supreme Court, was there such communication during that selection within the HQCJ? Well, both back then and during the competition for the High Anti-Corruption Court, communication was performed via publication of some infographics and speeches of the members of the HQCJ, as far as I remember. Do you think that this was insufficient or sufficient? Insufficient. What else should be done? Infographics, interviews, what else? And how? What should it look like? Well, I don't know. Maybe that could be done through a Facebook account, your Facebook account, or how could it be done? In what way? In mass media, on the internet. You could also invite distinguished experts of law for them to comment upon the procedure of the selection and qualification assessment, for them to convey the message to people, not the members of the commission, but these people, these experts. So the experts who, in particular, compiled the test items. Okay. You also suggest that at the stage of submission of documents for judicial candidates, you suggest that we should monitor the motivation letters in terms of plagiarism. It's a very interesting idea, but how could it be applied? Well, with this in view, we will need to make some amendments in the regulatory acts. Okay, but let's imagine that they have been made. Well, even now there is an opportunity like this. The person is not allowed to participate if the person has not submitted all documents. And in case the motivation letter has been checked within some anti-plagiarism software, and it has been confirmed that the motivation letter does not follow the integrity requirements, which means that the person has taken this text from some other people who also wrote their motivation letters, then the person, it may be considered that the motivation letter has not been submitted. And if the documents, the set of documents is incomplete, the person will not be allowed to participate. But this is on condition this mechanism is really fully present in the legislation, but definitely we will need some changes in the legislation. Have I got you right that you would also like to introduce the IQ test or the general abilities test? But we used to have it. Well, yes, but you want to use it on a wide basis. I would not remove it, at least, from the exam. I think it should stay there. What should be the share of points for this IQ test? And in this part, I would change something. For example, well, first of all, I would change not just the share, but I would also change the procedure of counting those points. There is no methodology for transferring the opinions into the score. And during the competitions for the Supreme Court and the High Anti-Corruption Court, I got the opinions. And these opinions had the following gradation: very low, low, medium, high, very high. And then, well, when I got the score for the qualification assessment, I could not understand what corresponds to what and what scores, what points have been put. That's why I think that it's necessary to develop the methodology. Like, you have a degree given, a score given by some psychologists, and this opinion should actually correspond to some number of points, which would be taken into account in the final recommendation, in the final assessment made by the HQCJ. Thank you. Let me give the floor to my colleagues. Steven, Serhii, you're welcome.
Thank you very much, Mr. Chairman, and thank you, Mr. Koliush, for participating in this competition. You state in your motivation what is very, very correct, which is that this is an extraordinarily important competition for the European Union, and it's, of course, an important competition for Ukraine. You put your finger right on that issue. We must elevate the judiciary of Ukraine, and we must increase public trust to the highest European and international standards. Is that not correct? And I ask you, as my colleague Mr. Brookhuizen has asked you, where can you better or more effectively achieve this? You're a very capable individual, very clearly, and I think where is Judge Koliush most important in trying to respond to the European Union and to elevate Ukraine's judiciary? On the High Qualifications Commission, of course, you have to identify the very best of the best judges, correct? And you must also be among the the best of the very best judge selectors. Is that not also correct? And you must assess competence and commitment to reform and, of course, integrity. As I listen to you in the first few minutes of your interview, I hear about testing and computers and algorithms, and I ask, is that truly what an honest man like yourself uses to assess whether another man or woman is equally honest? Does the computer produce the number 25 or does it produce the number 38? Is that how we assess moral foundations and character and standards? By speaking with the local psychologist and looking to see what the computer says, which number it says? What have you learned from all your many experiences in the selection process? You've got an extraordinary background in the selection and involving yourself in these kinds of competitive processes. Do you tell the European Union when they ask you, we have used 37 as a number of character, not 36. Thus, we are doing everything we can to respond to the European Union. I'm exaggerating a little bit, but tell me, is that how we determine the best of the best in terms of moral character? Maybe an IQ test will tell you something about competency, but are tests really appropriate for telling us the measure of the man or woman in your judgment?
Well, of course, psychological tests and IQ tests are only a component, one component of checking integrity of the person who has submitted the documents for the judicial position. After that, of course, we have to study the dossier, we must have an interview, and it is mostly during those procedures, research into the dossier and the interview, that we shape up the opinion. And that's where a member of the HQCJ comes into play, so to say. And during the interview and while studying the dossier, he or she has to clarify whether the person is the person of integrity and whether really this person has sufficient professional competence. You know, me as a judge who has been working for quite many years in the judiciary, I'm accustomed to paying attention to details, all the more while considering cases on some corrupt offenses and corruption-related offenses, because these details can really help me investigate into the case much better than it would have been done by some other person who is not paying attention to details.
So that really is your everyday job as a judge. It's to measure credibility and honesty in many cases, isn't it? Don't you do that on a regular basis? And how do you do that? What are some of the means by which you judge whether a witness or a party or somebody is honest or not honest in your judgment? They don't have a polygraph detector in the courtroom, do they?
No, I don't use polygraph, of course. Of course, we don't use polygraphs, but, well, we can judge by behavior of the person, but the confirmation and assessment of that openness occurs on the basis of analysis of all the materials and all the merits in the case, after some interrogations and study of documents. That is a tedious procedure. Comprehensive work.
If we were to appoint you to or recommend your appointment to the HQCJ, I think it would be because we felt that you were an honorable man, you were a man of integrity, you had the judgment to determine that quality on the part of people who applied for judicial positions, and that you could do a better job of that than could a question asking a candidate, Mr. Candidate, do you like to be alone with yourself? And those kinds of questions that one often sees on these tests. Is that a fair observation? Are you comfortable with that?
I'm not sure that I've got your question. I'm asking me already in the capacity of the member of the HQCJ.
We're assessing you to become a member of the HCJ. We're looking to see if you are that honorable man. You have a background that certainly suggests that you're that honorable man, but we're having the opportunity to meet with you here. I feel more comfortable coming to a conclusion by this interview and by assessing your dossier than I do seeing if you got the right answer to a test asking whether you were comfortable being alone with yourself. Do you understand?
Yes. And that is exactly what I started talking about. The very process of assessing the competence and integrity of the person consists of several components. Tests, as you have noticed, but of course, this process ends up in the dossier and the interview. And I feel comfortable about making conclusions on whether the person meets the requirements on the basis of the dossier and the interview.
And you think you can do that to the standards that the European Union is demanding that the High Quality Commission, Qualifications Commission do these things, right?
I think yes.
Let me ask you one final question now. You've been going through this experience for the past year as you've gone through prior experiences. I mean, what is your sense about whether this effort by the Selection Commission will give more impetus to Ukraine's application to the European Union than prior competitions have? What is it that we're doing right? What are we doing wrong? What is your sense about the effectiveness of this process to respond to the concerns of the European Union and to allow Ukraine to determine its own future?
Well, of course, I think yes, because you mean the Selection Commission, right? That is now choosing the members of the HQCJ, yes? Of course, if the Selection Commission for the HQCJ makes this selection and selects competent people of integrity, the level of trust in the society, in the Selection Commission and in the HQCJ will rise many a time. And, well, you know, this could be seen by the example of their selection for the High Anti-Corruption Court, because there was a board of international experts involved in that selection together with the HQCJ, and I think that this is the best example of such cooperation between the staff body of Ukraine and international experts. And the trust in our court, as I feel, and as statistical data shows, is high. So I think that if your commission proceeds in the way you are doing it now, and you select the best of the best, of course, these people will also select the judges who meet the standards of the EU, or at least are close to that.
And if we place you on the High Qualifications Commission, you will never forget your commitment to a righteous and highly professional judiciary. That's what you've told us. If you're elevated to that commission, you will do everything that you can to ensure that that is what we achieve in Ukraine. Is that correct?
Sure. And that's what I'm dealing with right now, and I will keep doing this in the future. That's my commitment, and I will continue with that in case I'm elected a member of the HQCJ.
Thank you very much, Judge. Appreciate it. Yeah, please.
Thank you, Stephen. Thank you for giving the floor to me. Good afternoon, Mr. Koliush. My name is Sergei Verlanov. In response to the question asked by Judge Markman, you mentioned that as a judge of the High Anti-Corruption Court, you study all the circumstances of any corruption. So that is why I have this question for you. How do you think, how should we check the integrity criteria within HQCJ? So should you be appointed as member of HQCJ, how should the integrity criteria be checked? Integrity of candidate judges and incumbent judges during the assessment. Well, there is a procedure already established by law and the existing methodology, but I would suggest that we pay more attention to the materials that we receive from relevant bodies on request of HQCJ. So I know what circumstances should be studied in more detail as a judge. That is why I would pay more attention to these materials in order to identify any circumstances or evidence of facts that prove a person lacks integrity. What specific authorities or bodies do you mean? Materials provided by which bodies? As far as I understand, when you're checking integrity, you are requesting information from NABU. You're also requesting information from State Registry of Powers of Attorney. As far as I remember, you are requesting materials from an ACP as well. So everything that tells us a little bit more about property status, about involvement of a person in transactions that could be evidence of the fact that they lack integrity or have some illicit property. Thank you. Thank you. My next question. In its activities, HQCJ interacts with PIC. In your opinion, what key problems or issues should be solved in this interaction between HQCJ and PIC? This is really a complicated question. We have seen this interaction between HQCJ and PIC during previous selection procedures, selection for the Supreme Court in particular. I think this interaction was not regulated enough. There was lack of mutual understanding. Since I've already participated in the selection for the High Anti-Corruption Court, and since I'm aware of the activities of the Public Council of International Experts, I would suggest that this council be involved further. But of course, that will depend on the availability of budget funds or the ability to cover such expenses during regular qualification assessments, not just selection to the Supreme Court of Ukraine, let's say. But if we look at the provisions of effective law, I think we need to initiate amendments into the existing law. We need to specify the responsibilities of members of PIC for those opinions or conclusions that they are providing to HQCJ. And there should also be requirements for members of PIC established, because there are not too many prescribed by law. Then the trust in their opinions will enhance, and the level of trust between them and the members of HQCJ will be increased. Thank you. Do you agree with the idea for compulsory consideration of negative opinions provided by PIC? Do you mean this suggestion in the new anti-corruption program? Yes. So if we have this regulation, the one that I mentioned before, then possibly yes. But at the moment, I would disagree with this. Thank you. Your position is clear. I'm passing the floor to the chair, Ivan.
Yes.
You have any further questions, right?
Certainly.
Certainly. Well,
Just warming up.
okay.
You are a member of the High Anti-Corruption Court. Can you tell me how many judges have been prosecuted in the High Anti-Corruption Court?
Конкретну цифру назвати не
I cannot give you a specific number, but it wasn't a low number.
It was?
Wasn't a low number.
So there have been several.
не трохи, не мало.
It wasn't a low number, not a small number. Not a small. Well, this is semantics.
Достатньо.
Quite enough, let's say.
How many
Ну,
do you think?
Ну, цю статистику я не підіймав.
Well, I did not check the statistics, but
Одна справа щодо
I did have two cases that I personally heard, so I already made judgment in one of the cases, and
якщо порахувати
the second one has not been decided as yet.
ВАКСа,
But if we look at the number of judges of the High Anti-Corruption Court, so that will amount to 50-60, I guess, if each judge has two cases involving a judge. But this is not exact statistics. I was not interested really in the statistics.
And I don't know whether you can answer this from your position as a judge. What kind of cases are that? What kind of corruption do you see?
це в основному отримання неправомірної вигоди.
That was them getting a bribe.
Або
Okay. So this is not something which is special. It happens if so many judges are being prosecuted in your court. Because what I find difficult in sitting in my chair and listening to all the people we interview is whether the vetting of candidates, what the idea is of the HQCJ, will take out indeed the corrupt people. Do you think it will work?
хотілося б досягнути такого.
At least that's the result that would be desirable. I don't know whether it will work. Time will tell.
Треба до цього прикладати всіх зусиль.
We need to put as much effort as possible. That's the result I'm hoping for, of course.
Боротьба з корупцією, вона полягає не тільки
Fighting corruption is not just about convicting
полягає
corruptioners. It's also about prevention of corruption.
краще відібрати тих осіб,
That is why it's better to select people who will not be committing any corrupt activity than later prosecute people who have already been corrupt.
I think what, of course, helps enormously if people who commit corruption or bribery are prosecuted, because then the people see that also law exists for judges. And I think that it is extremely important for the trust of society in the judiciary system. Don't you agree?
згоден з вами.
Yes, of course, I do agree with you.
And in that respect, what I found strange, but maybe I don't understand the system well enough, is that when there are allegations against the judge of corruption, that the judge can stay in his seat until indeed NABU or another institution starts prosecuting the judge. Should that not be different or change?
На сьогодні процедура саме така, як
At the moment, the procedure is as it is. Removal from a judge can be done only by the decision of HCJ.
так і є у нас у законі.
This is what is prescribed by our law.
Звісно, можна передбачити якісь інші.
Yes, maybe we can foresee a different mechanism for the removal of such a judge,
Але він повинен бути прийнятий на законодавчому
but it must be adopted on legislative level.
внесені зміни до закону
There must be amendment introduced to laws.
на підставі Конституції.
because we are acting according to our constitution and the law on the judiciary and status of judges. And until we have amended those, it cannot be done in a different way.
Well, I can predict you that if Ukraine wants to become part of the EU, then the EU countries wish to make sure that their investors will not have cases before judges that are seen to be corrupt. So I cannot see in the future, but I predict that something like that will be necessary.
Зрозуміло, вони будуть хотіти.
Yes, it's understandable that they will want to have this level of judiciary, but let me repeat my opinion. Article 19 of the Constitution of Ukraine foresees that every government body should act only within the mandate that it has under the law.
Of course.
Our government bodies cannot operate in a different way. I'm not quoting the article of the Constitution, but that's the main sense. You cannot do anything unless you have the mandate for it.
No, I understand that, of course. That's in any decent country. You should always act within the mandate of the law. But the question to you was, would you think this to be a good idea, or is it not a good idea?
Звісно, для гарантування
Yes.
того, що
In order
наші стандарти
to guarantee the compliance of our standards with European standards, we should amend the procedure on the level of legislation, as I already mentioned.
навіть у законопроекті з цього
But unfortunately, we don't even have draft laws at the moment that would suggest such amendments.
Do you know what is influence peddling? I'm sure that you know what that is. Let's say trading and influence.
ще раз не
Sorry?
так, звісно.
Of course.
Of course.
Стаття.
I'm not aware how it works in Ukraine, but according to the United Nations Convention Against Corruption, the UNCAC Convention, I believe Article 18, it is advised that it is a criminal offense. Let's say influence peddling, trade in influence. Is that also the position in Ukraine?
У нас це відповідальність. У нас відповідальність в загальних рисах.
Yes, there is some responsibility in our legislation for that. This is Article 369, Part 2. We have implemented these provisions in our criminal legislation.
Still, I hear, let's say, from all kinds of sides, even in the interviews, that it is not unusual that politicians contact judges if they want something to happen or not to happen. What is your view about that?
Такого не повинно відбуватися.
This is not something that should be happening in a democratic country with the rule of law, and it should be punished.
Okay. And is that also happening in your court, that trading and influence is prosecuted?
На нас не здійснюється зовнішній вплив
There is,
інформації.
at least to my knowledge, nobody has done this within our court.
And is it a good idea that that happens fast, especially if it regards judges and or politicians?
Покарання не може бути застосовано поза межами певної процедури.
We cannot punish people outside of established procedures. Quick punishment doesn't always mean lawful punishment.
Of course. But how long does an average corruption case takes until there is a judgment in the first instance?
It takes a long time.
Після розгляду чи під час розгляду першої інстанції.
So during the hearing of the case or during consideration in the trial court? Could you please specify?
Until there is a judgment in the first instance.
На жаль, довго.
unfortunately takes a long time. Unfortunately, this hearing may take a long time.
So there are judges who are still active as a judge, even though they are being prosecuted during this long time. Okay.
Yes.
Якщо вони не відсторонені від посади,
If they have not been removed or suspended, then yes.
Okay. As rapporteur, I have to ask you some questions about assets. And we have here a commissioner who's, let's say, a specialized assets guy, and I'm not, but I will try. If maybe I say something wrong, because we have to look at all those information. It's translated for us, and we sometimes have difficulty to understand how it all works in Ukraine. But so I hope I don't make mistakes, but I do my best. And if I do it wrong, please tell me. In your property declarations, you have submitted in 2017, 2019. You indicated information about an apartment with an area of 62.3 square meters in Luhansk. You acquired such a right of use in October 2013, but it was not reflected in the declarations of property, income, expenses, and obligation of financial nature for the years 2013 to 2015. As well as it was not reflected, it says here, for the years 2015 and 2016. What can you say about this?
по-перше, це було не право власне.
Well, it wasn't the ownership right if we are talking about the apartment with the area of 62.3 square meters. Am I right?
Yes.
That's the one you're talking about?
Yes.
Це не право власне.
This was not ownership. This was the right to reside in the apartment. And when I was filling out the declaration for the year 2013, so we used to have these paperback declarations, not e-declarations, back in the day, and they were a little bit different from the ones that we are currently having, the ones that we are currently filling out. So I believed that in section 3 of the declaration real estate, I needed to indicate only the property with regards to which you have some documents or some title documents. With regards to that apartment, I had no agreements, and it was the apartment belonging to my sister where I lived with my family. That's why I indicated it in section 1 as place of residence.
Well, our chairman will know how it exactly works. I don't know, but I'm told that also when you use an apartment, you have to declare it, and you had to declare it. Is that correct, Chairman?
Right.
You told me always it's very difficult, those declarations.
It's not easy. At least it's not
But
easy.
if you are a judge in the High Anti-Corruption Court, you should know how to do it, shouldn't you?
Ну, звісно, всі ті помилки, це помилка, яка виявляла...
Yes, it was a mistake that I was pointed to during previous selection procedures. And starting from 2017, I already rectified that mistake, and I filled out my subsequent declarations in a correct way. But at that time, there were no explanations, no instructions as to how to fill out declarations. And many people believed that if you indicated your place of residence in section 1 of the declaration, you didn't need to indicate it in section 3 once again if you didn't have any title documents to that property.
Okay. I have also information here about a apartment of 68. Is that the same? Let me see. 68.3. Oh yeah, 68.3 square meters in Kremenchuk, Poltava region. And that apartment is owned by a Garagan Taisha. And apparently it's used by you or your family. And this was also not recorded in the property declaration 212 to 15. What can you say about that?
Вказану квартиру за таких же ж обставин я не зазначав.
So the circumstances are the same for me not declaring this apartment, for not mentioning it in section 3. So
Дозволу власника.
in 2015, we started living in that apartment. I think it was December, I'm sorry, of 2014. Since we are IDPs, we moved from Luhansk to Kremenchuk, and we didn't have any other real estate at the moment. And we didn't want
Тобто офіційно договору
to have any rent agreements. Well, it was not our initiative. And this apartment belongs to an acquaintance of ours. I did indicate this apartment as our place of residence, and we were first registered. Me and my whole family were registered at this address as IDPs.
однак я її не вказав.
But I did not indicate it in the section about real estate because I believed I had to declare it in section 1, place of residence.
Okay.
Ми її не орендували цю квартиру.
We did not rent the apartment. We paid utility bills for that apartment, and that's it.
Well, the only thing I say is that if you are elected in the HQCJ, of course, you will discuss with others the correct filling in of documents and declarations. And it is then important, of course, that the members of the HQCJ have filled in those declarations themselves properly. And but I understand your explanation. I understand from our chairman, who has explained it many times, that it is very difficult and difficult to understand, and you always do it wrong. But it is our task to confront you with these facts. And my last question to you is, and that's fine, in your motivation letter you said, as an example of your integrity, that you have never been brought to administrative responsibility for violating the traffic rules. And of course, it is very good that you have never been, ever in your life violated the traffic rules. But I'm wondering whether this is an example of real behavior that shows integrity. It should be a lot more than, I would say, not going against the traffic rules, isn't it?
Ну, скажімо так, це один із прикладів.
Well, it's just one of the examples of me being a person of integrity. It's not integrity as
Sorry about the
such.
question.
Oh.
Okay, Mr. Chairman, the ball's to you.
Пане Олеже, в 2016-17
So, dear Ola, in 2016-2017, we had the selection for the Supreme Court of Ukraine. In 2019, we had the selection for the High Anti-Corruption Court.
19-му, так?
Was it in 2019?
19.
2018 through 2019, yes.
І ще багато процесів відбувалося.
And many different things, many processes were happening at this time in the judiciary.
Відповідно до соціологічного
According to surveys,
проведено в серпні минулого
a survey done in August of 2022 by the fund Democratic Initiatives named after Ilko Kucherev, as of August 2022,
політичним партіям
people have the least trust in political parties, in judiciary, minus 46%, government authorities, minus 46% in trust. We don't know what the situation is at the moment, but approximately a year ago, the level of distrust in the judiciary was minus 46%. Can you explain this phenomenon?
Це питання постає вже давно. І
Many people have been raising this question, and as I have seen, it's not the first time you asking this.
дійсно наявність певних
Well, first of all, we do have some issues in our judiciary, issues connected to integrity of some judges. But as correctly mentioned by some of the candidates who you already interviewed, and I believe even you have mentioned this already,
рейтинг довіри
The
особи, яка приймає участь у судовому
surveys
набагато більший, ніж
have
тієї особи, яка ніколи в суді не була.
depend on who you ask, whether it's a person who had any immediate experience of going to courts or whether it's an outsider. And also politicians and some people related to politics sometimes make too many statements about the judiciary and they bear no responsibility for making these statements. Because as far as I remember, even in the strategy of judiciary development, it is foreseen that we need to prevent any instances like that, and I completely agree with it. But how do you see this in practice? How can you prevent a politician, how can you forbid a politician from expressing their opinion about what is happening in the judiciary? At the moment, we have this draft of the Code of Ethics for MPs. It has not been adopted as yet, but we also have codes of ethics for civil servants. And we need to make sure that they are followed. And in the law on the judiciary and the status of judges, it is prescribed that you may be punished for libel and slander of a judge, but there is no norm that would foresee the procedure for holding a person to account for libel or slander. Well, but this is a dead end then. Politicians are referring to the data of surveys as a ground or motivation for their words. They continue saying that the judiciary reform is imperfect, and as a result, we get these numbers. So are the politicians the only one to blame? Of course not. No, it's not just about the politicians. I also mentioned it at the very beginning. And there are different cases from my own experience when we have judges who lack integrity. We have cases like this and we need to fight it. Fight and you will win. But it's also a comprehensive task. It's not just about us punishing corrupt people. It's also about conveying the right messages to the society, conveying the situation with the actual state of the judiciary. So we are going to select members for HQCJ, and I believe that there will be high level of trust in this HQCJ, and this will result in a high level of trust of judges appointed by the new HQCJ. And in such a way, I believe that we can gradually enhance the level of trust in the judiciary from the public. At the same time, we need to do everything to regulate the statements made by politicians. Do it on a legislative level. We can think about some kind of responsibility for them if they are making statements that can harm the judiciary, but it should be regulated by law. At the moment, unfortunately, we don't have mechanisms like this one.
We don't have mechanisms like this. Thank you for the answer. Are there any other questions to the candidate? No questions. Please, Oleh, our interview is about to finish. So how would you like to sum it all up? What are the core things you would like to still tell the Selection Commission? Maybe you would like to address someone. Please, the floor is yours. Well, once again, let me express my gratitude for the opportunity provided to me to participate in this selection, to express my vision of the operation of the HQCJ during the interview. Unfortunately, now we have war going on in this country, which is, of course, introducing changes into all the activities, all the fields of activity of the society. But even in such complex times, we Ukrainians still keep thinking about the future and keep dreaming about living in a free and democratic state. Thanks a lot, dear commissioners, for your contribution into the reform of the judiciary. I think that your work is really important for the future of the judiciary. And I'm sure that you will recommend
правосуддя дійсно компетентне.
really competent people of integrity to the HQCJ.
Ми зможемо побудувати
I believe that we will be able to build the judiciary people will trust. And on my part, I will do my best
використовуючи всі
to achieve this using my skill, all my skills and abilities. Thank you for attention and glory to Ukraine. Glory to heroes. Thank you, Oleh. That is the end of our interview. Good luck. Stay safe. Goodbye.
на все добре.
Goodbye.